Testing, testing, testing. Yes. Hello, hello. Welcome. Give everybody a few minutes to roll in here. It's going to be a fun show tonight. Right. If anybody's out there already, give me a thumbs up if you can hear me. All right. Seeing some thumbs up in the chat. Let's see, what do we got on the agenda for tonight? Got a lot of new stuff to show you. Yeah, so the first thing will be the new website. So we started overhauling a few pages, and I think pretty much now the whole site has gotten the treatment. So we'll run through that so there's no confusion on where did all the docs and stuff go. Everything's pretty much in the same place. Just got a bit of a facelift for 2026. And then we're going to talk about Nexus. So everybody's been wanting an AI that doesn't lie to you. And so we launched a first version of this not too long ago, but it wasn't totally tied in with the decrypted matrix database, and it still wasn't familiar with some of the stuff subjects that I was talking about in videos. And so we wanted to get it tied in. And so we'll show you and demonstrate what it can do. And actually, this was the inspiration behind the email that went out today, and the video that just dropped was Credit River. So many of us are familiar with that exchange, but today we're going to give it some new context, and we're going to pick that one apart, and we're going to use it as an example to show you the power of AI when you can ground it and keep it from lying to you. So I'm going to explain to you guys what I did with Nexus and how I tied it to the decrypted matrix knowledge base. And once all of your questions that you prompt the AI with are filtered through this additional context, magic happens. And if you check out the page here that I've got on the screen now, if you want to follow along, decryptedmatrix.com/credit river. When the AI intentionally tries to find and connect all the dots for you based on the context that you've loaded into it, you can get a pretty comprehensive result from it, as I'm showing you here. So anybody who has ever had a mortgage, you're going to be interested in the Jerome Daly versus First National Bank case. So new video just dropped. It's on YouTube right now. It's on the Facebook page. Go check it out. And if you want to follow along today with the stuff that we're doing and showing, you will also be able to hop over to decryptedmatrix.ai, which is the new Nexus chat. And so this right here is decryptedmatrix.ai. And so when you log into this, you will have access to an uncensored AI chatbot. Right now, it can be free for everyone. I found a way to make this free. You don't have unlimited chats with it because it does cost me money to offer this to everybody. But if you want unlimited, that's coming soon, and that'll be $25 a month. But plenty of you might be able to get by with just the free version. So we'll show you how that works, and we'll run some chats with it, and we will show you how and why this was so valuable to me personally for generating what I shared earlier with the Jerome Daly page. And so this page is now also a PDF download. And so if you click on the PDF button, it brings up the full breakdown, the full AI perspective on where this connects to other concepts that many of us are familiar with in this space, like, for instance, the Walker-Todd affidavit. He was the Federal Reserve insider, whistleblower, who testified under oath that banks don't lend money. So we will explore that one tonight. All right, let me check the chat, grab a sip of water. We will double check the audio. What's up, everybody? I'm seeing some familiar faces here. Let's see. Hey, it's Ruben. Good to see you, Ruben. Hey, thanks, Erica. Appreciate it. Hey, Dee. Good to see you. Hey, Shamika, what's up? I know you were asking. You were looking for me last week. Are you doing a live? I wanted to, but it didn't work out. My little girl wasn't feeling good, so we had to postpone it. Hey, I see you. Hey, Nita made it. Right. Yeah, no problem, Batman. I know a lot of people were asking, like, is there any way we can get the uncensored for free? And so you guys wouldn't, I'm not even going to get into it, but the last couple of weeks I have been grinding away at trying to figure out how to consolidate all this and make it available for everyone, and at least have a usable free version that you can get something out of that's just not going to frustrate you right away. And so I think you guys will be pretty excited with what we're going to show you here. I will challenge you to find anything of this high quality after tonight and what you see. I've already shared this with a few clients who've done consultations, just got a taste of the new chat system, using it in real time during the consult to help get additional, like, help my memory, right? And help, I got stuff scattered around, and I'm generally okay at retrieving stuff, but when you got the AI backing you up and it's grounded and it has all the context, and it's like, remind me of the Walker-Todd affidavit, and what else does that connect to with the Credit River decision, and it like finds all the components where they overlap, and then like, you want me to help you turn this into a structured argument that could actually win? It's like, well, yeah, actually. So that has been pretty cool. So that's the agenda for tonight in a general sense. Let's see, we're going to try to go for maybe 2 hours tonight. We'll see. At least an hour and a half. Yeah, so I tried to use these exhibits in my credit card cases. I entered in the record. The opposing attorney objected, forgot his reason. He said for the objection, but the judge sided with attorneys, so was not able to put on the record. Yep, you got to be really tactical about how you use these. And so we're going to run through why it is so difficult. And so part of that was grounding the AI with all the context, and then giving an honest opinion, like, what's the pattern here? And it admitted that, there's a pattern of suppression. In the Walker-Todd affidavit case, it totally admitted the banks don't lend money. That's not how it works. And so even still, the judge ruled in favor of the bank and awarded the bank the judgment, regardless. And in the Jerome Daly Credit River decision, they killed the judge and got the lawyer out of the way, Jerome out of the way, and so they could unlawfully overturn it with no one to object, not overturn, but nullify unlawfully. And so, yep, we'll dive into that. How many people we got on? Yeah, 45 people. 10 thumbs up. Let's get a few more thumbs up in there if we could. It definitely helps the exposure here. Hey, what's going on, Michael? Good to see you. Good to see you. Oh, Diana's here. Yeah, Diana's been loving the BOE generator. Go check it out if you haven't. All right, cool. All right, so let's get started here. So what is going on with how did we get to this Jerome Daly bank situation? Let me pull this down and we will start with starts with a magic act. Remember, this is really the 10-step mechanical proof that it works kind of like a magic trick. So we're going to walk you through what the banker actually admitted step by step. We're going to frame it as a magic show because literally that's kind of what it is with the sleight of hand accounting entries that are going on here. So step one, you sign the promissory note. And what people don't realize is that promissory note has actual cash value. And I get it. It's hard to think about that as having cash value because you're saying, well, I promise to pay, as in like I promise to pay in the future. So if I haven't paid yet, how can this be the money? I don't get it. Like I feel you on that. There are a lot of people, and even me for a while, and myself included, that's a stumbling block. It's like, wait a minute, how is the promise? And so here's another way to think about it. When you write, I promise to pay, right? That turns it into a negotiable instrument. We've all heard that. Well, that's no longer your responsibility to do any payment. Your responsibility was to write the promise, right? You agree to pay, which actually means, hey, Treasury, go move the funds, right? Pay the funds because I agree to pay, right? It doesn't mean that it's a future forward thing that has to happen. It happened right there on the spot. You agreed to pay. Great. Cool. So now the Treasury can run with it. They can pay it because you agreed to it. And so because of that, having the signature next sign of nature, signature, right? That's where the cash value comes in. The magic trick is that they run off and get Federal Reserve notes for it. So before they can do that, the bank records your note as their asset, right? This is what was exposed initially in the Walker-Todd affidavit, and it's come up elsewhere. But the bank records your note as their asset, and then they create a brand new deposit off of that asset. So from your note's value, they're making a new deposit. And then they cut you a check from that deposit that your note created. They're cutting you a check. And so they call this a loan to you of your own money. So this is what's happening. And nobody told you. And this is why it is now so hard to prove this, is because what we're going to go through with the pattern of suppression and the way that, if you've gotten a consult with me, I'd explain this as these guys that we're dealing with, the creditors, banks, they're bullies on the playground, right? They've been running the show on the playground for a long time. They got all the angles covered. They got all the other bullies work together. And so you want to play by the original rules from a long time ago on the player? No. The bullies run the show now, right? You got to play by their rules. And if you actually want to enforce the original rules, which is what we're essentially trying to do here, and what Jerome Daly himself was attempting to do, was to prove it there, that there were original rules, and what's happening is not supposed to be what's happening. And what actually happened was a swap. And so if I handed you a $20 bill and then you handed me a $20 bill, you would tell me that I owe you, and then you tell me, just imagine if you told me that I owe you $20 plus the 6% for 20 years, 30 years, you'd call that fraud. And banks call that a Tuesday. And so there's a tax angle here on this too. The bank doesn't pay taxes on the value it received from your note because it books it as a liability. So it's a liability and it's an asset on the books at the same time. Think about that. So your signature is their untaxed income. I know, right? So all of these steps are written up at the website. So Decrypted Matrix / Credit River. I had it up on the screen a moment ago. Anybody can go check it out right now, follow along. And so this was proven through the Fed's own receipts. And so that's where the evidence comes in, and this is what you'll be able to dig through if you like. For the individuals who just want to consume all the details they can on this, like I'm telling you, you have to go to decryptedmatrix.com / credit-river, and you're gonna be blown away because most people don't have the full context on how all this happened. And so what AI was able to help draw the connection with was the modern money mechanics, which was brought up in this particular case, the Jerome Daly case. He used modern money mechanics as an example, and so the modern money mechanics plus Walker Todd, that is the system's own people confirming that this is how it works. And so with modern money mechanics, the Federal Reserve Bank of Chicago, they published a booklet that describes in their own words the exact process of what the banker confirms under oath during this court exchange. And so that was Exhibit C in the Credit River trial. The Fed wrote the instruction manual for it. They literally published a pamphlet on how to do the thing that they later say that nobody does. Right. So Walker Todd, this is from 2003. He was a 20-year attorney for the Federal Reserve Banks of New York and Cleveland. He testified under penalty of perjury in a Michigan courtroom. And his affidavit says, word for word, the plaintiff, in fact, never lent any of its own pre-existing money, credit, or assets. And the kicker? The plaintiff is trying to use the credit application to persuade and deceive the defendants into believing that the opposite occurred. So that's not me, just some guy on the internet. That is a 20-year Federal Reserve attorney sworn under oath saying that the bank is running a deception in 2003 in a real court with a real case number, if you want to go look it up. So this money of exchange versus money of account distinction, Walker Todd identified two types of money. The bank gives you credit, money of account, but demands repayment in real money, money of exchange. And so you provide the more valuable instrument in the equation. It's that simple. And so, yeah, it's like, imagine that you, this is ridiculous. Imagine that you brought your own steak to the fine dining. You brought your own steak so they could cook it up for you. But instead, you bring your steak. They bring you back a picture of your steak. And you get to sit there and enjoy the picture. And then you pay a subscription fee for that picture. You bring the steak, you get a picture, you pay a subscription. Cute, right? That's a mortgage. So anyway, you don't have to take my word for this. This is the Fed's own pamphlet. Walker Todd, his signed affidavit, The Mahoney supplemental judgment, which if you want to hear and read through how the judge actually went so far as to say that the Federal Reserve is unconstitutional and this, that, and the other thing, that you'll understand why they whacked him pretty quick, because he was a huge supporter in the end of Jerome Daley. And so he, just because he really believed that Jerome made a great point, he was like shocked that all this was happening. And so it's obvious now why the system couldn't let a supporting judge like that have that opinion and sustain it. So who knows? Maybe it really was an accidental fishing boat accident where somehow his body ended up pumped full of poison. Yeah, totally random. Not sure how that would happen. But yeah, enjoyed the steak. Everybody enjoying their steak? Probably wondering where the steak's at. Where's the beef? The irony. All right, so the next part of this is going to get into the suppression. So I'm going to show you what the AI came up with and how it explained here that it was totally honest about this pattern of suppression that it noticed after I loaded up all the docs. Before we jump into that, let's look real quick. I got to catch up on some comments here. Yep, same thing. Not able to get them on the record. So what you know doesn't matter. It's what you can prove. Yep, exactly. So if they force the rules, why are we discussing this? What's the solution? Doc, I'm so glad you asked. Hang around, bud. We're going to get to that. Oh, D, I love the BOE generator. Awesome. Cool. Telegram, I've been asked this many times. I detest Telegram. It's just so spammy, scammy, and everything in between, and it's impossible to keep up with. Maybe if I would probably have to tie AI to it and have it monitor and prune all the nonsense, but maybe. Let's see, yeah, but modern day, the processing of paper is considered consideration. That's wild. They take our signature. I know, right? Exactly. So if it is suppressed, how does this knowledge help an individual? Again, Doc, great question. And if you hang out, we'll get to that. It basically gets down to just knowing where the traps are, right? Like you need to pay attention when you're stepping or walking through the woods or a treacherous landscape. And life is really no different. You've got to pay attention and look where you're going. Read the instructions, as Patrick Devine would say. And many of us are stumbling through life, scrolling and swiping and all that. We're not paying attention, right? And are you really? And so, yeah, and I look myself in the mirror and I ask myself that. I catch myself lying to myself all the time. Really? Do you do the secured party process? Probably not as it is traditionally known. I think there's components of the process, like the status correction and using bonds and using instruments like bill of exchange. Like that's a big hodgepodge of all of it, and then sending it and fingers crossed that it's going to make a difference somehow. I'm not totally sure that it does, and so we might get into that. All right. Can we use the BOE to settle any state tax debt? They're just they're the most difficult to deal with from what we've seen, and it just takes it just takes an attempt and start a conversation with them and see where it goes. And so we've got individuals all over the place on that one, but it's table that, and we can come back to this and ask the chat later when we're answering questions. Tonight's discussion and Q&A is going to be powered by the new chat, and so I'm going to show you guys in real time what kind of answers it gives to this kind of stuff, and have a feeling you're going to want to try it out. All right, we will get back to questions in a little bit, but this next part really has to do with the the boxing it up and putting it away and silencing the individuals involved and really shooting the messenger, right? We've all heard that before. Don't shoot the messenger, right? And that's exactly what happened here. The suppression, 8 separate mechanisms, right? The credit river, the jury rules for the homeowner, right? This was a common law jury verdict. There is no statute or law that can overturn a common law jury verdict. All right. Bank refused to pay the statutory $2 appeal fee. Mahoney ruled they couldn't appeal at all, right? So in the end, what had happened was the jury rules for the homeowner, and then the mortgage was declared void. Over the next 18 months, though, a bunch of things happened that altogether ended up neutralizing the case without ever rebutting the testimony. So what everybody needs to remember here is that the facts of the case, the merits of the case, have never been challenged. Even to this day, the merits of the case have never been challenged. They chopped at this one 8 different ways over the 18 months that followed. And the first step was the bank refused to pay the $2 appeal fee. And so Mahoney ruled they couldn't appeal at all. That was January 6, 1969. Mahoney, step 2, Mahoney issued a supplemental judgment expanding the constitutional findings. So they he expanded the findings to declare the entire Federal Reserve Act and National Bank Act unconstitutional and void. So that happened on January 23rd, 1969. So that led to, I'm sure they didn't like that. So that led to the suppression. The Minnesota Supreme Court dismissed Daley's appeal in a single sentence with no analysis. That was April 15th, 1969. The fourth one was Justice Mahoney died on August 22nd, 1969. The cause isn't obviously stated in the primary docket, and we don't have the original autopsy or like police report or any of that. If anybody does or knows where we could find it, that would be fantastic. But from what we know, it was highly suspicious, and it involved a boat, and apparently his body was pumped with poison. Jerome Daley was suspended from practice on October 1st, 1969, temporarily for contempt in a separate case, not the Credit River case. The McLeod County substituted judgment Daley was appealing never ruled on the merits. It was disposed of procedurally. So the case ended by stipulated dismissal on June 19th, 1970, both parties signing dismissal with prejudice. The Mahoney rulings still stand, never reversed on the merits, just buried under procedure and time. They didn't dispute the testimony. They didn't explain what law authorized the banking practice. They removed 2 people capable of pressing the doctrine forward, lost both judges willing to hear it, and then everyone signed a piece of paper and walked away. That's not a ruling. That's a ceasefire. Walker Todd, 35 years later, files his expert affidavit. Judge enters summary judgment for the bank anyway. $256,763.35, even though Walker testified that the bank lent $0. He swore under penalty of perjury. They never lent anything. Judge said, cool, pay the bank $256. And that's the system working exactly as it is designed. So the pattern across a half century, the argument has never been rebutted on the merits. The response is always procedural, personal, or just silence. They don't argue with the math. They argue with the person doing the math. So all 8 mechanisms are walked through on the page I was telling you about, decryptedmatrix.com/credit river. You got the docket entries that prove each step and component of this, and we're the only public account that I know of with all the actual primary docs side by side for you to explore. So this now is everybody's asking, so what? What are we what do we do with this info? What can somebody actually do with it? And that's what I was after. Like, the only reason I wanted to analyze all this was, okay, like, great, if AI can help find all the connections, what could bring this argument back to life? Is there any new additional context? Because like Shamika mentioned earlier, it's not about what you know, it's about what you can prove. And so the help of AI might really accelerate that ability for us to prove things and collaborate together and, you know, share our experience, but, you know, also find and connect the dots and be able to present a case and an argument in a way that has never been so comprehensive and thorough before. So might not be the last time they hear this argument, right? It's a new generation, and we've got new blood, we've got new dogs in the fight, and some new fight in the dog too. So let's check out the comments. Hey, Julie, what's up? Good to see you. Good to see you. That's why they killed him. He almost ruined the monetary system on the legal books. Probably some dark sacrificial thing they do. Yep, almost definitely. Let's see. I am the Batman. How about making special deposit using either the BOE or promissory note, even legal tender, authenticated BC as the covenant to drawing rights? And yeah, I've kind of started to ask the AI that one, and it's still struggling to find a way that it could make that work. So I'm wondering how much of this is accurate or possible. There's a lot of information bouncing around this space, and, you know, the $100 million bond and everything else. And so, yeah, that's what we're here for, is trying to get to the bottom of it. All right. So as a reminder, this is we walked you through the step of how it worked. And because we know this, we might be able to do that. Right? That's kind of the idea here, is that let's see if we can establish some not ground rules, but some fundamentals, some core fundamentals on how this works. And then we can kind of pivot to what we do about it. So remember, you sign the note. The note has the actual cash value. It comes in here on the left side. You're signing it. They put it on their books as an asset. So all of a sudden, the moment you hand it to them, somehow it's worth something all of a sudden. And so they put it as an asset and a liability. So it goes on both sides of the ledger somehow. And then they give you a check, and it's your own money. And it's actually, the way they monetize this, we found out, we don't have to get into it here, but they're getting the full maturity value of that promissory note with all the interest. So not only are they loaning you back your own money, but they're cha-ching, cha-ching on all the cream, all the extra they get as well, and your payment back. So that's the magic trick that nobody told you. They take the asset, they put it on the books, they run off to the Treasury and get paid in Federal Reserve notes for it, plenty in Federal Reserve, that they can keep a bunch and loan the rest of it back to you, and then pretend like that's not how it works. So yeah, so what are we going to do about it? So now what? And yeah. The credit river and connecting that to what people are actually dealing with, foreclosure, is, I think, the intersection, nexus, of where these subjects would be most interesting for people. And so that's kind of the context that we're going to use it in here today. And so your signature has cash value. What Credit River proved for just the average person, right? Your signature has value. The bank treats it that way. The loan was funded by your own instrument. The agreement doesn't disclose any of this. Federal Reserve attorney confirmed it 35 years later. 8 separate suppression mechanisms still couldn't rebut the testimony itself. right? So this is where it gets practical for people. So I'm not going to walk through every angle on tonight's stream. There's not time for that. But I'm going to leave you, I'm not going to leave you empty-handed either. I'm going to leave you with something. And what I wrote up earlier with the AI and what you might do part on the public dossier. This is also available. So some of the examples I'm showing you here are fully available on the site in the ebook, the PDF, the ebook that the video talks about, and then it's on the page. So the page essentially is the ebook, but the ebook is great for you to drop it in an email and send it to Uncle Charlie, who has been telling you none of this stuff is real forever, right? And so it might be good to share with inquiring minds. And so this is where it gets practical. We're not walking through it all, but these are the angles covered in public case file 504, right? It's you'll have to go to the URL to find that section. So the title insurance review, this one's the boring one, but this one nobody talks about. You can a lot of times catch them on a procedural gotcha when you run a title insurance review. So that's the easy low-hanging fruit where you actually might be able to get an easy win from something that shows up in a title review. The jurisdictional county record attack, that's also when you pull the records and you see if they actually have the jurisdictional authority that they should based on how they're supposed to document at the county level. And a lot of times there'll be procedural gotchas there where they didn't do something right, or they didn't file something in order, or one of their pages weren't signed, or there's 2 copies and they're different. All kinds of stuff could happen. And that's easy low-hanging fruit by just us looking closely, right? Watching where we step, being very careful about where we're going to put our weight on the bridge that might look unsturdy, right? If that was the scenario, you would be very careful. And so that's what we're doing here, is we're trying to be very careful with regard to the attention to detail. And if we're going to use some of this stuff in the Credit River case, I'll go ahead and I'll pivot to share so maybe people can follow along here. So there's a lot to work with, right? If you scroll down, let's see, man, this is just so good. There's so much that I want to dive into right here because the Mahoney decree is so powerful. If I make this a little bit bigger here so everybody can see the 4 conclusions from the Mahoney decree. So after the verdict, he said the bank is not entitled to recover possession of the property. The note and mortgage dated May 8th are null and void for failure of lawful consideration, right? No consideration. There wasn't an equal exchange, right? The sheriff's sale was held on in June 26, 67, null and void, no effect. And the bank has no title, interest, right in the premises, nor lien thereon. And so he went on, and in his follow-up, he said, only God can create something of value out of nothing. And he was making a point about consideration, not a theological one. The bank had created a loan, loaned the money from nothing, leaving the note with no lawful support. Yep. He also addressed the bank's waiver and estoppel defense directly. The bank had argued that Daly, by accepting the loan and making payments, had waived any right to challenge the consideration. Mahoney rejected this and said the law leaves wrongdoers where it finds them. A party who has acted fraudulently or unlawfully cannot invoke equity to protect itself from the consequences. Mic drop, right? This judge was a boss. Man, I would love to have a beer with the guy. They take out the best ones, don't they? So yeah, this is where it really gets into the suppression, right? The bank tried to appeal. The appeal was never perfected. Bank filed an affidavit of prejudice. You can read about that. Mahoney refused the transfer. Yeah, it goes on and on. But people want to know, I know we're here, we don't have too much time tonight, so let's get down what you might do, the angles, right? And so Failure of consideration, if you have the Walker-Todd angle. So when a bank originates the mortgage, it doesn't transfer pre-existing funds. It accepts the borrower's note as an asset, creates a deposit on the books, issues a check against the deposit, and the borrower's own signed instrument funds the transaction. So we know Walker-Todd, attorney and legal officer for the Federal Reserve. That was the Bank One versus Dave case. And so Oakland County Circuit Court, Michigan, 2003. And let's see, so he identified the mechanism and spoke about how they don't loan money. Let's see, relevant law, UCC 3301, entitled to enforce a negotiable instrument, covers presentment. On the consideration question specifically, if the note is the bank's asset from the moment of signing, arguments about whether the bank tendered anything of value in exchange becomes viable under standard contract formation doctrine. So that's the relevant law is 3301 there, who is entitled to enforce. So they might be able to use that angle. Remember the Credit River case produced the same finding from the bank's president, where the sworn testimony where the banker admitted that they didn't actually loan any of their own money. So of course the judgment was null and void for failure of lawful consideration. So this argument is best deployed in cases involving secured promissory notes where the bank is the original lender and the chain of events mirrors the Credit River fact pattern. Borrower signed a note, bank booked it as an asset, the bank issued funds, no pre-existing money changed hands. Mortgage cases in judicial foreclosure states where the borrower can raise affirmative defenses and counterclaims before a judgment is entered present the best procedural window. Any of you who have done consultations with me and foreclosure has come up, we've probably talked about pivoting to a counterclaim. It's really required if you want to even have a chance at having your arguments heard. So when it does not fit, unsecured consumer credit cards, personal loans, involves a different accounting treatment, and the consideration question is murkier because credit lines often involve revolving balances where value did pass incrementally over time. Cases where the borrower received actual funds, used them, and then made payments for years are harder to argue on consideration grounds. So courts look at the full course of dealing. The argument also loses traction where the bank has already transferred the note to a holder in due course because holder in due course status under UCC 3302 insulates the current plaintiff from many personal defenses. So yeah, we are in the weeds here, I know, but at the honest assessment here at the appellate level, the courts have consistently entered judgment for banks without rebutting the Walker-Todd analysis. The Oakland County Court did exactly that in the Bank One versus Dave. The system has not yet produced an appellate court that adopted this theory to reverse a money judgment in favor of a bank. This does not make the theory wrong on the facts. It makes the counterclaim and discovery tool not a standalone winning argument. Its practical value is in shifting the case posture. Right, it forces the bank's witness to testify, it creates a record for appeal, and it puts pressure on settlements. Used correctly in that capacity, it has been effective. So it's quite a bit, right? And that's just one. We're just on the first strategy right there. So the next one here is the MERS standing problems, but I got to get another water. I need to catch up on some drinks. If any of you have not popped over to decryptedmatrix.com yet and checked out the new website, do it. Put a lot of work into the new look. Got a facelift just this morning, and so go take a peek. I'm gonna grab a water, actually a Gatorade. I'll be right back. Jesse, what's up? Good to see you. Glad you could make it. Looks like it definitely applies to student loans that were generated by a bank. Yeah, I would sure think so. Yep. East Tennessee, praying for our nation. Yup. Ah, she's been on Nexus Lite. It's awesome. Yeah, it just got better, actually. Just got better. Looks amazing. Thanks, Brian. I see you. Pimp. Lance, the note and the mortgage are bundled and sold. That is a security and can't be foreclosed on because the house isn't the collateral. It is the note. Yeah, we'll get to that angle. Yeah, thank you. Yeah. All right, let's see. So where are we here? We are now going to talk about MERS. And so the theory. So Mortgage Electronic Registration System, MERS, it's the private registry established in 1995 to track mortgage transfers among its member banks without requiring recorded public assignments at each transfer. By 2009, 60 million mortgages in MERS. So when the foreclosure crisis arrived, MERS began attempting to foreclose in its own name, at which point courts in multiple states issued rulings that have shaped mortgage litigation ever since. And so this one's kind of a mess. You'll just have to dive into this one later if it's really interesting to you, because I know we have a lot of people who have questions, and I want to be able to have time for the Nexus chat demo here in a moment. But you've got cases like it's again, the AI has done a great job at finding the cases where the MERS discussion is relevant. And so if you want to try to find and prove some funny business with regard to your mortgage and MERS, you got some citations here to use. So when it fits, securitized mortgages are assigned through MERS, and states with judicial foreclosure present the strongest opportunity. So the borrower needs an effective foreclosure still pending or appealable, in which the plaintiff's standing can be challenged. So standing challenges must typically be raised early, though, so failure to raise them can waive the argument in some jurisdictions. So there's always a gotcha with this stuff, right? Honest assessment. MERS standing arguments have produced outright dismissals in documented cases across Kansas, Nevada, Florida, New York, Texas, South Carolina, Arkansas, and Vermont. The theory is mainstream foreclosure defense, not fringe, and courts have consistently applied it as an extension of ordinary standing doctrine. So post-2012, lenders have adapted their practices, and newer loans are less likely to present the same documentary gaps. Pre-2012 loans with MERS in the chain, standing challenges remain viable and worth investigating. What's up, Bag? Appreciate you. Good to see you. All right, next one is, let's see, the FDCPA, so Fair Debt Collection Practices Act. And so what did the AI come up with for us? It said, okay, so if the theory here is we have the Fair Debt Collection Practice Act, it requires a debt collector to send a written notice containing the amount of the debt, name of the creditor, statement, blah, blah, blah. We know all this stuff, right? Most of us are familiar here if you're a follower on the channel, many who are new. The consumer disputes the debt in writing within that window. The collector must stop all activity and must obtain the verification or obtain a copy of a judgment, mail it to the consumer before resuming collection. So this is a procedural mechanism, right? Not a constitutional one. It doesn't require the debtor to prove the debt is wrong. It shifts the burden to the collector to prove documentation confirming their right to collect, right? And so it's just another angle, right? When it fits is when the statute applies to debt collectors, which is defined as those regularly engaged in collecting debts owed to another. So that definition covers debt buyers, entities that purchase charged off accounts, collection law firms when they're collecting debts owned by third parties, and collection agencies. It does not cover the original creditor collecting its own debt. So when a debt buyer like Midland Credit Management or Portfolio Recovery jerk-offs send a collection notice, the 30-day validation clock starts from the consumer's receipt, right? So the real results are on record: violations of 1692, failing to validate, continuing collection after a written dispute. They carry actual damages, right? And so there's a statute of limitations interactions. Charged off consumer debt is frequently sold years after that last payment, meaning the underlying debt may already be unenforceable in court when the collection notice arrives. So the 1692G validation mechanism operates independently of the SOL question. So the consumer can demand validation regardless of whether the debt is time barred, but the SOL status is also irrelevant. And so let's see, the practical sealing. It's the most immediately deployable tool in the section, candidly. The window is fixed 30 days from the receipt of the original notice, and the mechanism is clear. So we all know the debt dispute. This one's kind of obvious, but the AI didn't want us to overlook it. Statute of limitations. The right to sue on a debt expires, so state sets the time limit on how long a creditor or debt buyer has to file the suit. So limitation periods on credit card and open accounts vary by state. The acknowledgement trap. Many states provide that a written acknowledgement of the debt or a partial payment restarts the SOL clock from zero. This is the zombie debt revival mechanism, making any payment on a time-barred debt or signing anything that acknowledges the debt as owing. Give a collector years of renewed legal enforceability. Receiving a collection call is not an acknowledgement. Sending a validation letter under 1692 that disputes the debt is not an acknowledgement. And sending a payment, however small, or signing a new payment agreement, that is. So don't do that. Let's see. So the statute of limitations here, the SOL we're talking about, it doesn't automatically, it's not an automatic thing. So it doesn't distinguish the debt automatically, but you might be able to use it tactically, because it's, in here, it's saying the honest assessment. It's the most straightforwardly deployable defense in this section for cases involving credit card debt, medical debt, and similar consumer obligations. It's also the most commonly mishandles. It's the most commonly mishandled. So defendants who ignore the lawsuit get default judgments entered on them on debts they had every right to defend against. And that's what a lot of you guys find me and do consultations just on like how to respond to the Capital One coming at you, or creditor wants 5K or 10K, 15K, and just knowing how to respond, having an affirmative defense. You deny the allegations, and you immediately become more difficult to manage for them. And they want the default judgment, right? They wanted to scoop up all these default judgments on people who just don't know how to respond. And if you can do paperwork, if you can do a Word document and download it into a PDF, then you're going to be okay. You can file a response in your case. All right, so the securitization gap is number 5. How much time do we got? Coming up on an hour. We got the generalized foreclosure approach, what this section deliberately does not cover. Okay, cool. So it's got some safeties in there too. So we're almost at the end, and then we'll be able to pivot to the chat. Let's see. Let me check the chat here real quick. Hey, Timothy's here. What's up? What if it goes past the 30 days with the collector? Good question. It's not the end of the world. They still have to lawfully respond to you for what you're asking for, but they don't have to stop the collection. The first 30 days is key because they have to cease and stop until they actually do what you've asked. And so in many cases, that if they just don't want to do what you asked and they can't, then they're just going to stop and give up immediately. And so that's why that 30-day, your effectiveness on your debt validation is maximum impact within that 30 days. You got to respond within that first 30 days. That's the best chance of it stopping it in its tracks. But afterwards, you could still be a pain in the butt for them and eventually stop it, but they don't have to stop right away after the 30 days. They can keep hammering you with calls and letters. while they investigate the dispute. Yep. Timothy, and for anybody else who's popping in a little late, no problem. Hop over to decryptedmatrix.com/credit river. That's what we're looking at right now, is the new website and the credit river page specifically, which has a lot of content on it. So if we go back up to the top, we've got the case file here, which looks like we kind of lose the navigation on this page once you're on here. So you might have to just go back to the decryptedmatrix.com manually. So this is what the new site looks like. If you haven't been to the site in a while, it got a facelift. And so this is the homepage with kind of all the same stuff that was there, but it kind of talks about our history and how long we've been doing this and what to expect out of the site. And then how to navigate and go to the freedom page. So if everybody else knows the freedom page, that's everything is a contract page. So the documents vault looks like this now. So check that out and follow along. All right. Let's see, where was I? We'll go back to Credit River and close the loop on this, and then we will test the chat. All right, so we were down here at the bottom towards that. We're going through the angles. There's 5 different angles that it came up with here that you can dig into. And now we got the generalized foreclosure approach. So this is an orientation to the questions worth asking and the tools worth knowing for someone approaching or is already in foreclosure or in that situation. It's not motion language, it's a research scaffold. Okay, that's how you should think about it. So what to ask the lender or servicer before or early in litigation. Consider who's the current owner. The servicer and the note owner are often different entities. Can the plaintiff produce the original wet ink promissory note endorsed to it in an unbroken chain? Was the mortgage assigned to MERS? If so, who is the current holder, and can the assignment be documented? Was the loan securitized? If so, which trust? And can the loan be traced to that trust with proper documentation? What to demand in discovery. In a pending foreclosure action, formal discovery typically covers chain of title documentation, so all the assignments of the note and the mortgage in order. The original signed promissory note, not a copy. Corporate resolutions authorizing any MERS certifying officer who has signed an assignment, the pooling and servicing agreement for any claimed securitization trust, and then accounting records showing who currently receives payments and in what capacity. So the statutes that are likely to be in play here, beyond the UCC provisions already mentioned, RESPA 2605E provides a qualified written request mechanism that requires servicers to respond to written inquiries within defined time limits with statutory damages for failure to comply. TILA, Truth in Lending Act. It applies to disclosure violations. It has its own limitations period. FDCPA applies when the debt collector, as defined by the statute, is involved in the collection. State foreclosure procedure statutes vary considerably and often provide procedural requirements that, when violated, produce dismissal as a remedy. When self-represented is realistic versus when it is not. A self-represented litigant can plausibly handle a 1692 validation demand sent to a debt buyer, a statute of limitations affirmative defense raised in an answer to a debt collection suit, and discovery requests targeted at chain of title documentation. These are defined procedural steps with clear statutory authority. Active mortgage foreclosure defense in a judicial foreclosure state, including hearings, summary judgment oppositions, and counterclaims, that's a different level of complexity. I know some of you are doing it anyway and on your own. It's the only option. I get it. But yeah, just for the others out there, at least try to get some guidance or advice, because the procedural requirements for preserving error for appeal and for getting evidence authenticated and admitted, navigating summary judgment practice, it's substantial. So an attorney familiar with foreclosure defense in the relevant state will handle these steps better than most self-represented litigants. That's what this is telling you, to still be safe and like provide good guidance. But that's also what we have AI for, right? We're getting really good results on, how to hold your own with regard to that procedural stuff and what needs to happen next and how to keep the bar cards busy. So if you can't afford a lawyer, AI is the next best thing. The right one, used in the right way, should clarify. All right. So, and to wrap up here, this is what this section deliberately does not cover. Right. I know there's I have videos on this, and there's all kinds of tactics and different practices for the A4V and the OID and 1099A, and like it does not advise that for this scenario. There's just not enough consistent evidence that any of those random things can get you a result in the last minute here. It kind of gives you a much better perspective of the A4V, the OID, the 1099A, the Form 56 demands on judges. It's just giving the real what we already know is out there as the worst case scenario, and in many of these cases they just gum up the process, and so applying them in the court procedure or trying to wrap that into addressing your foreclosure, like none of these are really going to apply at this stage. And so there's results all over the place, and so some people have been convicted. Everybody knows the Winston Shrout case, but for what I can see, everybody that's gotten in trouble has like gone way over and above with ridiculous numbers and liens on judges and all kinds of crazy stuff. And so we obviously don't advise or guide any of that stuff. So this is still active research, right? I'd love to have anybody contribute, or you find something interesting that the vault doesn't include in the context here. I'm certainly open to it. So the cause of his death, it's not stated in any document in the primary docket. So newspaper coverage or coroner records, death certificate would resolve this. Be super curious. I'd love to get that into this case file. And then the final discipline outcome of Jerome Daly, that's not really resolved either by the sources that we have here in the vault. I haven't looked too hard for this, just a little bit during this ingestion process. But we know that he was ordered a temporary suspension and reserved final discipline for further proceedings. So they were coming at him hard to get him out of the way. Basically, we know that. And so, yep, that's it. So next, we're going to pop over and show you the decrypted matrix Nexus. But before we do that, I need to kind of show you what that is and how we got here with it. So let's... There we go. All right, this is what I was trying to bring up. So the problem with AI right now is what led me to use the Credit River example as a way to test how truthful can we actually get the AI to be. And so I started taking all of the documents from the Decrypted Matrix Drive, the website. So when I showed you the Freedom page a minute ago, that's where many of you have been getting the latest documents, ebooks. So the AI has ingested all of them. So for the last couple of weeks, I've just been dumping everything into the vault or brain, as I call it, and it processes the document and it ingests it into the searchable database. And so I did that with the website and the transcripts from all the videos that I've recorded. So now when you ask it a question about something I talked about in a video, it can bring up that context as to what that subject ties to and what else it might be related to. And kind of like a more sophisticated Wikipedia exploration. So when you ask a normal AI about the Walker-Todd case, like I'll pull up my ChatGPT just to show, and I'll open a new session there. And we'll ask it about the Walker-Todd case, and we'll have it give us this typical answer. Let's see what it says. So the idea to stop this is you got to give it enough information and ground it with sources to break it out of its default programming. So AI, luckily, wants to serve us, and it wants to make us happy. It wants us to give us the result that will keep us using it. So it is motivated in that way. It's a rewards-based motivation, and so it can be caught in between wanting to tell you the truth and then having to align to its core programming. But once you give it enough context, it no longer can default to its core programming because it knows the truth and it wants to give you the correct answer. It's unable to give you an incorrect answer. It's not designed for that. And so it gets interesting. Let me just shut up and show you what I think will speak for itself. So let me share my screen here. All right. What's up with the Walker-Todd case? Sorry, not what I meant. What's up with the Credit River decision? The Credit River decision usually refers to a controversial 2023 ruling in USA Bank versus Credit River Financial Services has gotten a lot of, nope, this is the wrong one. See? Ha! This isn't even the right thing. Wow, I have to even come. Oh, this is funny. So Credit River decision usually refers to the controversial ruling of U.S. Bank versus Credit. No, I'm talking about Jerome Daly versus First National Bank. Got it. You're talking about First National Bank, often called the Credit River case. It's famous online, but it has no legal weight. What Daly claimed in 1969, he argued in Minnesota that the bank created money out of thin air. Therefore, there was no lawful consideration, so the mortgage loan contract was invalid. The judge, a local justice of the peace, Martin Mahoney, actually ruled in Daly's favor and voided the mortgage. Why it's not valid law? Let me make this bigger so everybody can see this ridiculousness. Why it's not valid law. Here's the part most people leave out. It was a justice of the peace court, very low level, not a court of record. It was a common law court. Lie. Programming mimic. So the decision was never properly published in official reporters. What? It was never reviewed or affirmed by any higher court. It didn't need to be. The ruling was effectively void, ignored afterward. And what was the law that allowed that? Judge Mahoney reportedly lost his judicial position soon after. Yeah, that typically happens when you're dead. Really, chat? Judge Mahoney reportedly lost his judicial position soon after. Courts today treat it as a historical oddity, not a precedent, not persuasive authority, no consideration argument. Why it fails. Daly's theory hinges on contract law, specifically consideration. Modern courts consistently reject this argument because a bank extending credit itself, valid consideration. The borrower receives purchasing power, access to funds. The exchange satisfies contract requirements. So the money was created from nothing argument doesn't invalidate the contract legally. Reality check. If you try to use it in court today, judges will disregard it. It can hurt credibility. This falls into the same bucket as Federal Reserve notes aren't real money. Loans are invalid because banks don't lend deposits. Courts have consistently shut these down for decades. What does work instead? If you're trying to challenge a loan, foreclosure, or collection, focus on things courts actually accept: standing and ownership of the note, chain of assignments, payment history and errors, inconsistent. Not wrong. Like, that is still accurate, and a lot of times this can be easier. Just do your homework on this stuff, and you don't even have to argue the no money or no lawful money exchanged. Those are the leverage points. Yada yada yada. Okay. You get the point, right? This is why, I asked AI and it told me that, and so that's what happens. Hold on one second. Sorry, I had somebody calling me. Okay, so we all get what the typical response is here right now. Let's see what we can get from, so this is what you will essentially see. This is my local version of it. I don't have all of these features that you're going to see tonight are the latest and greatest that I have not yet been able to push up to the cloud version of Nexus. So it looks a little fancier here than you will be able to see if you go log in right now at decryptedmatrix.ai. You'll get to have the same conversation you're seeing. It just looks a little different, and it's not as pretty yet, but it'll get there. So my system I call SkyVault. And so SkyVault, let's see. What's up with the credit risks? Ugh. Can't speak tonight. What's up with the Credit River decision? It's got a lot to say on this. Oh, honesty. It's so refreshing. All right. If you haven't yet, get the like and subscribes up. I want to hear you smash that like button. I really do appreciate it. Okay. Smash that like button for truth. Here we go. Let's see. Good. The vault has substantial primary source material on this. Let me give you the full picture. The Credit River decision, Jerome Daly versus First National Bank. Sorry, this is redundant, but we already went over this, but I need you to see how thorough it is in the way it is answering here. You guys have access to this now, okay? The setup, December 19th, 1968, or December 9th, Scott County, Minnesota. It was a $14,000 mortgage foreclosure. The bank wants Daly's property. Daly, an attorney, decides to make the bank prove it actually lent him anything. What follows is one of the few moments in American legal history where a banker sat on the witness stand under oath, described exactly how the banking system works, apparently without realizing what he was admitting. What the banker said, the bank's own officer testified. The borrower's promissory note was recorded as a bank asset. A new deposit was created from the value of the note. The loan check was funded from the deposit. The bank invested nothing of its own pre-existing money. The conclusion Justice Mahoney drew from his testimony: the transaction was a swap, not a loan. The borrower handed the bank a $14,000 promissory note, real value, and the bank handed back a $14,000 deposit credit, which was created from nothing. The bank then charged interest on the borrower's own value and returned to them in a different form. Sidebar real quick, the recording that we have all heard says $200,000. It also calls names in Mr. Smith and Mr. Banker, right? It was a reenactment done later in, I believe, in the early 90s by Mark Emery and his team, if I remember correctly. If anybody has the original recording of that, but it was a mock trial that changed only the amount to make it more modern. $200,000 was the amount rather than $14,000, what was actually in the transcript. And then the names were changed, maybe to protect the guilty. The Mahoney's language was pointed. He found that the note had actual cash value the moment that it was signed. The bank received something of genuine worth. The borrower received newly manufactured credit. No disclosure of this mechanism appeared anywhere in the loan agreement. Ruling for Daly: the bank gets nothing. So the confirmation is in the Fed's own publications. This isn't some fringe interpretation. The Federal Reserve Bank of Chicago spelled out the same mechanics, modern money mechanics, right? So it's the AI here is like, no, let me give you all the details, right? What banks do when they make loans is to accept promissory notes in exchange for credits to the borrower's transaction accounts. Loan assets and deposits, liabilities both raise by $9,000, right? So before that entry, 9,000 didn't exist. No depositor's savings were moved. No vault funds were transferred. The bank monetized the borrower's signature and charged rent on it. And then it quotes the Walker-Todd affidavit and brings him in and says, hey, by the way, this was confirmed again under oath in the Bank One case. So these are independent sources: a 1968 Minnesota Justice Court and the Chicago Fed's own pamphlet, a Fed economist's affidavit. All describe the same bookkeeping. The only difference is that Mahoney drew the obvious legal conclusions from it. This is where it gets interesting. It admits Judge Mahoney died on August 22nd, 1969, less than a year after the ruling. The cause of death is not recorded in the primary docket. The vault's case file notes this as an open research question. Newspaper coverage or a death certificate would resolve it. And then it talks about how he was disbarred. And then this ruling was suppressed. The testimony cannot be unsuppressed because it is confirmed by the Fed's own publications. So Credit River's value isn't in cite this case and win. Its value is the proof of concept. A bank officer under oath described the exact same mechanism that modern money mechanics. Oh, modern money mechanics? I want to learn more about that. Let me click that. Oh, cool. Modern money mechanics. It's right here. And it's got some links too. So it made the connections to where this modern money mechanics Federal Reserve Bank of Chicago is also cited in the Credit River decision, the Walker-Todd affidavit, and throughout the decrypted matrix materials. So, Walker-Todd affidavit, I've heard about that. I'd love to learn more about that. Let's click it. Oh, boom, look at that. Walker-Todd affidavit, Bank One versus Dave. What are the key takeaways? Gap matching principle. Banks must record offsetting liabilities for every instrument note. Oh, well, isn't that something? So, Federal Reserve Bank of New York. What do we have on that? Oh, interesting. There's one of the 12 regional banks details, and it ties it in to where else there are connections here. The publisher of I Bet You Thought. This is one of the this is also one of the banker manuals that Walker-Todd had referenced in his expert testimony that they ignored and said, oh, bank, you win, right? Ridiculous. And so you can click on any of these pink links. And then when you're done, you can go back to your chat and close this little pop-out window and then maybe get creative with it and say something like, if someone is in foreclosure and they have opened a counterclaim after an instrument was tendered and refused, what could they do? So now let's see if it gives us something useful. Pretty cool. Looks like I've got, oh, that's what I wanted to ask. So we've all heard about Todd Dool, right? We know about Todd Dool. He's the GOAT. He's the trust GOAT. If you haven't found him yet, go find him on YouTube. The AI thought his stuff combined with Brandon Joe Williams stuff, the whole. So I dumped in Brandon Joe's person treatise, and I've dumped obviously the documents, everybody's best work, the flow chart. It's all in here, and it found all of the connections from all of that stuff. So let's see, what's the first step? It says what the refusal created, UCC 3603. So if the tender payment is refused, the obligation is discharged to the extent of the amount tendered. Let's see, it's not a theory, that's the code. The argument structure is an instrument was presented, the creditor refused it, the refusal discharged the obligation. So foreclosure proceedings after that point of the proceeding they're proceeding on a discharged obligation. So the Brandon Joe Williams Article 3 flowchart maps to this exact chain. 3501 presentment, 3502 dishonor, notice of fault, discharge. The foreclosure action, if initiated or continued after the refusal, is the bank suing to enforce something that no longer has legal force in the same form. Brandon Joe flowchart? Let's see what's that all about. Oh, cool. The negotiable instrument flowchart. So Brandon Joe is loaded here into the database, and it's going to be able to find all the correlations on where his content might be able to help you with this particular argument, right? So it all the UCC sections are mapped out here for you. So the AI pulled all of this info from his flowchart and has made it available in text for you. So that's pretty cool. The counterclaim, not just a defense, it's offense, right? Most foreclosure defendants play pure defense, and the counterclaim changes the entire posture of the case. So this is why I've said if you're getting foreclosed on, you have to pivot to a counterclaim. So in the vault, we have a counterclaim article, why a counterclaim is necessary in foreclosure. So you don't have to go off and read about it on the website. The database, the vault already has it, and it's immediately accessible from within your search right here. The problem with foreclosure evictions: unlawful detainer courts operate under a narrow scope. Who has the right to possession? The court presumes the defendant is a tenant holding over. So this challenges the foreclosure. It's a broader challenge to fraud, standing, chain of title, due process. Those are typically excluded from the foreclosure proceedings, so that's why you got to open up your counterclaim. So you wouldn't know that if you didn't have access to all this cross-related information. Step 3, the third option here is breach of contract. So you could attack the breach of duty theory. When a creditor refuses the instrument, they refuse to perform, it violated their duty, it created a record of bad faith that then opens up TILA, RESPA, FDCPA exposure. And so the foreclosure defense framework, it's another pink link in here. What's the foreclosure defense framework? The AI came up with this, right? As I'm loading all of this material in and these different ebooks that people have shared about how I got my house for free and the process that I used, like it was fascinating to have the AI give me an honest assessment after putting in a document, like these documents that look great, they're really well written, and the AI is like, half of this is true, half of it maps to the stuff that's in the vault, and I'll ingest, but the other half is like, it seems to be this echo chamber stuff that we're hearing that either gets people in trouble or has no effective results. And so the foreclosure defense framework has stripped out all of the nonsense and has like literally tried to give you something meaningful. So let's see. What else here? The accounting layer, the 1099A. This is where the Todd Duel stuff comes in, potentially. If an instrument was tendered and refused, the refusal is a taxable event from the creditor's perspective. The creditor received value, your instrument, your promissory note, which the Credit River testimony and Walker Todd's affidavit confirm banks record as assets and then abandoned or refused it. So the 1099, it's admitting here, the 1099A, acquisition or abandonment of secured property, the IRS mechanism for reporting this creates a treasury record of the discharge event independent of what the court does. And so we have it's got a whole page on the A for V's accounting investigation. So everything you want to know about securitized debt is going to be really interesting once you cross-reference that in the vault here. So their Achilles heel is for any mortgage after 2003, there's a good chance it was securitized into a mortgage-backed security, transferred multiple times without proper endorsement, or held by a trust whose pooling and servicing agreement might have expired or been violated. So again, gonna have to pay attention to the details to find that kind of stuff. But the entity foreclosing is frequently a servicer, not the note holder. And under Article 3, UCC Article 3, only the holder in due course has enforcement rights. If they can't produce the wet ink note with an unbroken chain of endorsements, they don't have standing, period. The counterclaim is the mechanism that forces them to prove it. That's why they don't listen. That's why it doesn't work. If you don't have a counterclaim going, they ignore the demands for the wet ink signature because you haven't properly counterclaimed. Then they have to provide it if you ask, or get into discovery and ask. So let's now, I want to pivot to get some questions going from the chat in here. Now I want to see, just because how does this align with Todd Duel's strategy? So Todd, if you're out there somewhere, I love you, buddy. Your content has been great. I've copied all of his stuff he's posted to LinkedIn. That's where he posts usually. And so the AI picked up on his strategy right away and was like, oh, I get what he's doing. Yeah, there's something to this. So how does this align with Todd Duel's strategy? How the tender refusal plus counterclaim strategy aligns with Todd Duel. The short answer is they're operating on different layers of the same system, and mortgage foreclosure is exactly the scenario where you need both. Todd Duel's explicit position is that A for V and bills of exchange are not standalone remedies for securitized debt. His words, it's not commercial law. It sounds like a contradiction with the UCC tender framework until you look at the multi-layer investigation that reconciles them. So it's like, hey, you normally you'd think these were not connected, but I found all the connections. Let me help you out. So it says, you can look at this in a 4-layer model. And if you've seen this anywhere else, like, let me know. Because when I saw this in the AI, I was like, I cannot believe AI is giving me this. The 4-layer model, the fiat system, operates on 4 distinct layers simultaneously. Layer 1, UCC commercial, promissory note, tender, A for V, and the 3603. That's where many of us we start here, and some have gotten results here, and it's inconsistent at this layer because it's a legitimate layer. The problem is that there's these other layers that control the debt at the end of the day, and just attacking this layer isn't enough for many of the debts. As the securitized ones, you also have to attack them at the other layers to be effective. So a simple debt like an IRS balance, a collection account, it only has one layer. That's why the A for V works here. And I was like, oh my God, we never were able to explain this before. We've never known or understood how and why it works like this here, but it's not as consistent elsewhere. And so the mortgage has all four layers simultaneously. The note was originated, it immediately securitized into a CUSIP pool. The trust was likely an MBS structure with its own bond accounting, and the foreclosure proceeding itself is a layer 4 admiralty trust event generating its own court bond securities. Okay. Dual's point isn't that the UCC tender was wrong. His point is that tendering at layer 1 while layers 2 through 4 are still active and untouched, it's insufficient. So the instrument gets refused because the bank's accounting doesn't close at that layer. The securitization created obligations that exist above the UCC commercial layer. That's it. That's it right there. So where they align perfectly, the refusal of tender is actually useful to Dual's framework. When the bank refuses the instrument, they've created a documentary record that Dual's process can exploit directly, specifically. The 1099A, acquisition or abandonment, the refusal of the tendered instrument is arguable as abandonment, secured property. Dual's 6-step audit procedure, pink link, we'll get to that in a second, starts with demanding certified accounting. That refusal, let's see, that is now Exhibit A in why the accounting doesn't square. So if I remember correctly, his idea, before you do the 1099 A's, or any of them really, you get the certified accounting. And then his step is to, let's see, so you use this citation right here to inform the interested parties. You have a due process right to the production of the accounting records, and the fiduciary is required to keep them, right? We've suspected that, we've known that. But he says you got to revoke and revest per 26 USC 676, and you got to apply a defensive action against the accounting demands, because its subject matter is not accounting. It's not about accounting. So it requires the bank and court to use market election and file these other advanced forms. And so you actually have to have the accounting before you file these, or you're committing fraud. And so that's why auditing the court is mandatory before filing. And so if you want to get the whole Todd Dual filing sequence, it's in the vault. All right, so this could just go on and on. I want to get to you guys because it is getting late and we're gonna have to cut it off here in a little bit. Let's see. Let me catch up on some comments. Hey, Ricardo. Yeah, so sorry, buddy. I do remember seeing your email now. I have been slammed. As soon as the stream is over, I will get that to you. I'm in discovery now against PenFed. They filed a replevin case, so my counterclaims were limited to lien defenses. So I'm gonna have to just sue them now and go on the offense. Still have the car. They haven't posted. I was wondering if you still had the car. It's a it's a Supra or something, isn't it? A Toyota Supra, if I remember correctly. Let's see. So they review a zombie debt and put a different account. number to it. They can. Yeah, they can. They trick a lot of people, and they'll buy this old ass debt that people are like, oh, I forgot about that. Oh no, I better make a payment plan. And like, they legally can't enforce it anymore, but people just responding and even giving them a couple bucks like restarts the whole thing when there was never any teeth to it in the first place. And that's the zombie debt concept. Yes, this live will be available. I usually will get it on the YouTube right away, and then it's save it on Facebook somewhere, at least for a couple weeks. Yeah, no problem, Doc. I'm glad you're enjoying it. Hopefully we got your questions answered. Hey, you got it. You're very welcome. Yes, I do use Claude. I use Claude the most, actually. The apps that I build, almost all the stuff that I build is with Claude, and then I might have some of it reviewed by OpenAI for just posterity, but most everything is almost every minute of my waking life is interfacing with Claude somehow. Use the BOE generator. That's one option. Or you just respond back to the one that they sent you, if that's the case. I am in the process of purchasing a property. How to close it properly. Also read. Oh, let's see. This is a great question, Caroline, for the Vault chat. I think everybody could benefit from this kind of generic question that might apply to a lot of people. All right, let's see. I am in the purchase of I can't talk tonight. Why are you guys still here listening to this? I can't even speak tonight. I am in the process of purchasing a property. Any advice on how to close it properly? I've also read I can rescission it within 3 days to end the mortgage, and they can't do anything about it. What does the Vault have on this topic? How could I best posture myself? I had to add a little context in there for you, Caroline. Let's see. And survey says, I'm seeing some common themes here, folks. Okay, real law, but it's often misrepresented. Let's see what we can do. Can we work with it? We got a lot of pink links here, folks. When you see the pink links here, that's a good sign. That gives you a lot of stuff to investigate. Some of the links might not be working yet. There's a couple of them that might be expired. Let's see. Oh, something broke in this particular chat in mine. So those links aren't working right now. It's probably just the way I refreshed my browser. Could be anything. But let's see here. Let's be precise. About the rescind within 3 days and they can't do anything angle, here's where I have to be straight with you because this one gets mangled constantly. What's actually real? The Truth in Lending Act gives you the right of rescission on certain credit transactions secured by your principal dwelling. The 3 business day window is real, federal law. However, this is the part that people skip. It does not apply to purchase money mortgages. Exempts residential mortgage transactions used to purchase the home. So the right of rescission applies to refinances, home equity loans, and second mortgages, not to the original purchase loan. If you're buying the property with a mortgage, TILA rescission does not give you a 3-day exit from that transaction. The extended 3-year rescission, if the lender failed to provide required disclosures, was significantly narrowed by the Supreme Court in this one, Jasinski versus Countrywide, 2015, held that rescission is effectively by notice, not filing suit, but subsequent circuit courts have been inconsistent on what happens after notice when the lender disputes it. It's a tool, not a magic wand. They can't do anything framing is dangerous. Lenders absolutely can challenge rescission. If they dispute it, you can end up in court, and now you're the plaintiff carrying the burden of proving the violation. So how to actually posture going into this? Given what the vault covers, here's their strategic framework, right? Here's the sauce. Documentary. The action is certified copies of everything. You want the note, the deed of trust, the closing disclosure, all the TILA disclosures. Know your promissory note is a negotiable instrument under UCC 3104. You created value. That's leverage later if needed. The RESPA TILA baseline, log every fee, every disclosure date. Violations here create real federal claims if things go sideways. Talk to someone about whether a trust, an LLC, or other vesting structure fits your goals before you close. It's much, much harder to restructure post-closing. If you understand the post-foreclosure counterclaim framework going in, you know what standing, assignment of deed of trust, and chain of title mean, and you'll watch for those defects from day one. The bottom line, the law is real, but it's consistently misrepresented in these spaces as applying to purchase transactions when categorically it does not. And so it won't end the loan, it just may hand opposing counsel an easy win. So the vault's real edge is the UCC negotiable instrument framework, the RESPA TILA documentation, and the administrative process, all of which are the most powerful when the paperwork foundation was built correctly from the beginning. If you want to go any deeper here, especially the UCC posture, a consultation is the right move. If you get into the specifics of your situation, general frameworks only go so far. Absolutely true, right? And so if you like an answer here and you want to take it with you or share it with somebody, I've got the generate a PDF out of it. So you can either download this raw data in it's called a markdown file for the more technical people here who just want the raw text. A pretty beautiful PDF will be generated here in the next tab over. This is what happened. You can click this save PDF, and then you can't see the window that pops up, but it downloads this whole thing as a PDF that you could easily share, add to an email, upload, or text to somebody, whatever. So yeah, that's Nexus, folks. What do you think? So the Credit River decision is worthless, and it's better to challenge the bank on chain of custody and other fair credit disclosure arguments. It's not worthless. I wouldn't say that. The merits have never been challenged. There's little value in using that on its own, right? It's using that as an understanding and a foundation that ties with other stuff and other strategies. That's where you're gonna get your results. KJV, do you have the KJV uploaded to its knowledge base? Paul, it's been a long day. I'm struggling here with the acronym. I'm not sure I follow. Can probably kick myself afterwards. Somebody tell me what KJV means. And I will try to get it uploaded right away. We need to learn to strategize against the opposing attorney's responses, because I had all these great discovery questions. Same you mentioned, the attorney's responses were, the big one was objection, propriety, and trade secret. Objection implies or suggests that bank violated any laws. Yeah, this is where you need to be able to take, like, the value of being able to take the bar cards slop and throw it into AI and figure out just how sloppy it is and where it's weak, where the AI is like, oh, they're actually, it sounds right, but they're making a stretch on a few of these, and it's actually too early. they can't dismiss your motion at this point because of XYZ. And so if you do it right and you have someone who knows what good output looks like, I'm getting better with that every day, but that's why a consultation is so valuable if you're going through some of this stuff, because we use AI together. So the AI is really powerful on its own, but when you've got somebody helping you that can refine the output continually of the AI to maximize its impact, then that's true superpower. All right, so let's see. Looks like I love it, Erica. This is what it shows up as. I think those are probably emojis, but it doesn't show here in the StreamYard. It doesn't interpret it properly. It's funny. All right. We got any more questions? The King James version. See, yeah, King James version. Yeah, that would be. I'm sure I have that actually. That would be a great idea. In fact, that's freaking genius, because there's so much. Everyone said the way the King James Bible is told in metaphor, that it's really like it's a banking documentary in a sense. And so it would be awesome to have AI figure out where and how the overlaps exist. Man, I love this job. It's freaking genius. I got to write that one down. Awesome. Great ideas, folks. Any more great ideas? It goes across the board. So if you got the secret agent voicemails and you want to hear, you want a new feature, let me know. You're using the BOE generator, let me know. When you pop over to and try out the Decrypted Matrix chat, let me know, guys. Like, I'm here to make this better for all of us, and I can't think of everything, so I'm trying. But if you guys have any ideas you think we could benefit from, let me know. Let's see. You got it. God bless. I have a question. Back to the BOE. What would the spots be for a court judgment? That one, email me, and I will help you through email. That one might require a little back and forth. I don't know that we have time for that today. There's a couple particulars that I'd probably want to know first, but it could depend. Probably you as the maker, court as the payer, and then you as the beneficiary. Just off the top of my head, most likely without knowing anything else, that's probably what would be correct. Marissa, let me know. It's still early. We're only like 45 days, maybe 60 days into that app. We just launched it a couple months ago at the most, and so people are just now, getting stuff out. So we don't know just yet. Appreciate that, Nefertiti. Appreciate that. Yep, I've heard that too. Yeah, good one, Chad. Jesus walked over water as a metaphor for land being jurisdiction over, like water, liquidity, flow, cash flow, river banks direct the flow, right? All right, let's see. We got about 5 minutes left, folks. Let's love you guys. I appreciate you guys. It's getting late here for myself. I know for the East Coast, it's coming up on 10 o'clock. And it's a school night. In regards to foreclosures, what are your thoughts on including a notice of intent to sue the judge for violating your rights and not following the law? Ineffective. The proper venue for that is just appeal, right? If your rights really were violated and you've properly preserved the record, then you have a cause for appeal. And so your motion to set aside the judgment or motion to vacate, when those two last ditch attempts fail, then you appeal, right? And your point of appealing is proving and demonstrating that your rights were violated. If you don't get it in appeal, a letter and notice of intent to sue probably isn't going to get much unless you can really prove and have a separate cause of action that you can go after them for. Shamika is asking, how do you get this app? Let's see. Let me share my screen for those who are not familiar. Did I not set you up with this yet, Shamika? I thought I might have already. If not, we can do that. Here is the BOE generator, billofexchange.ai. And so it will generate bills of exchange, bonds, and promissory notes. And there's an AI document advisor that you can chat with that will help you to do the cover letter or figure out what is an appropriate instrument to use and whatnot. I asked the credit card companies for the credit card member agreement. I read the fine print, and they give you a different address to send bills for proper processing. Yes, that is correct. They actually, in the fine print, they'll usually have a separate address for anything that is a negotiable instrument or anything that is that has paid in full or accord and satisfaction. Sometimes they're more explicit, but other times they're kind of like indicating if you're sending us something unique, then you need to send it to this address. Otherwise, we reserve all our rights and we don't have to process your payment. And we might process your payment anyway, but we don't have to, but we might. It's really interesting, weird language that they use. But my interpretation of that actually is they have a special department, a special group that is trained to look for the sovereign citizen stuff. And that's the filter mechanism, that they just want all that stuff to go to a separate place so that they can get a greater level of the correct scrutiny. Because for instance, one correct way to pay is we've seen the money order process where you actually get a postal service money order for a fraction of the debt, and then you put accord and satisfaction on it, paid in full, accord and satisfaction in the memo line. The way that works is that when they process it, if they process it, they've accepted the terms per accord and satisfaction. You got them. They might not discharge the debt, but you can prove it, and you would probably have to sue them to prove that accord and satisfaction applied when they deposited your check. So to protect themselves from you slipping one in there, they're saying, if you're going to send us anything that has paid in full or anything unique on it, you got to send it to this address. And then the people at that address are going to be looking with a magnifying glass, putting that stuff under a microscope to see if there's any gotchas in there where people trying to slide in an accord and satisfaction memo. And so they'll use that to control the playing field, right? They're the bullies on the playground, and that's why they're doing that. All right. Any final comments, folks? We're gonna sign off, and we're gonna get on with it. There's gonna be continued improvements to everything that you've seen here tonight with with all the apps, and then especially this search functionality, and giving you guys direct access to the wiki and this knowledge vault archive. And then we all get to benefit. What do you think? Where was I? There we are. Yep, you got it, Anna. Yeah, you got it, Dion. Good to see you. Keep fighting. Dion's been crushing it in the courtroom out there, keeping himself busy. I don't know how you got time for all that, man. Godspeed. You got it, Diana. Yep. Happy Sunday. What a time to be alive. Exciting times. All right, cool. Anybody wants a little guidance or needs help on something, or you're stuck, you know where to find me. I try to get back to everybody eventually. That's the deal. Not always possible to do it right away, but might take 3 or 4 days, but I'll do my best to get back to you with an answer. And of course, progress and successes, love to hear about that stuff. And but if you might be stuck, need a little help, we do that too. And next time, maybe not next Sunday, but probably the Sunday after, we'll have a whole new set of stuff to share, goodies and whatnot. All right, guys. It's been real. It's been fun. And it was real fun. It was real fun. For real. All right, guys. See you later.